The adjuster says you're 30% at fault, maybe 20, maybe 40. Whatever the number is, I want you to understand something most injured people never hear. The percentage is not a finding, it is a negotiating tactic. I used to work the other side. I was an insurance defense lawyer before I started representing injured people in Arizona. My name is Garrick McFadden, and I own the Phoenix law firm GAMESQ. And I'm going to show you how this actually works. By the end of this video, you will know 3 things. Why you're being told you're partially at fault, what evidence actually controls that number, and how a lawyer pushes back so your case is not quietly devalued. Let's start with the rule. Arizona uses a pure comparative fault law that basically, let me tell you what it means in English. Your recovery is reduced by your percentage of fault. If your damages are $100,000 and you're assigned 30% of the blame, your recovery drops by $30,000. That's why the adjuster cares so much about sliding a percentage onto you. Every point of fault they assign is money that leaves your case. Now, here's the part most people miss. The adjuster is not a judge. The adjuster is not a jury. The adjuster is an employee whose job is to close your file for as little as possible. So where does that 30% come from? Usually from one of 3 places. First, your own words. A recorded statement where you said, "I didn't see him until the last second." That one sentence becomes a fault argument. Second, the police narrative. Officers write quick summaries. They're not accident reconstructions, but adjusters treat ambiguous language in the report as if it were gospel. Third, assumptions about speed, distance, or attention that are never actually proven. Things like, you could have avoided it, or you were following too closely. No data, no measurements, just a story. That's how 30% gets built. Here's what a lawyer does to dismantle each one. On your words, we control the communication. No more recorded statements, no more casual calls with the adjuster. On the police report, we treat it as a starting point, not an ending point. Sometimes we pull 911 audio, we look at the scene photos, vehicle data, the independent witness accounts, or we go walk the scene ourselves. On the assumptions, we replace stories with evidence. Crash reconstructions, black box data, timing, sightlines. When the file shifts from the narrative to proof, that 30% often collapse, sometimes to 10%, sometimes to 0. And the settlement posture changes with it. Here's what I want you to take away from this. If an adjuster has told you you're partially at fault, do not accept it as a verdict. It is an opening move. You're allowed to ask what evidence they're basing that number on. You're allowed to say to a no to a recorded statement, and you're allowed to get a second set of eyes on your case before you sign anything. If you're hurt in a crash in Arizona and an adjuster has started moving fault onto you, you can contact GAMESQ. You can contact me, my law firm. We'll tell you honestly whether that 30% has evidence behind it, or whether it's just a number designed to shrink your case. This is general information about Arizona law. It's not legal advice. For your specific case, you need to reach out to us and we'll tell you what you need to know, and we'll review your case. And many times when they put fault on us or onto you, we file a lawsuit. And that changes the fault discussion. Because at GAMESQ, it is always your injuries, our fight, your win.